Welcome back to the Register's Report. My name is John Buckley. I'm the Register of Deeds of Plymouth County. In this segment of the show, we always do something educational in nature. Donna Rodriguez had an idea that if we brought in the history, how a recording works in stages, that would be very important for people to understand. So we've done 6 episodes, this being the 6th episode, from starting with a lender with a pre-approval letter, going to an attorney who talked about the importance of treating your offer as a contract, the role of a realtor, a home inspector, an appraiser, and now we have a closing attorney. Franklin Triffletti of the law office of
Triffletti and Costa.
Triffletti
PC.
and Costa,
Yes.
PC.
Yep.
Well, thank you for coming on, Franklin.
Thank you for having me, John.
Want to just talk a little bit about your firm?
Sure. So we're a law firm here in Plymouth. My father started the law firm. I think we're closing in on our 50th anniversary. We have 4 attorneys in-house. We have a 5th attorney who's our title attorney that holds an office in our office space. We have many paralegals. We've been doing real estate conveyancing for decades. We also practice family law, estate planning, and those are areas of law that overlap with real estate. As you know, sometimes when people get divorced, they have to sell the house, or sometimes when a person becomes deceased, the estate has to sell the house. So it's nice to have that overlap where an estate client can then come to me and deal with real estate issues as well.
Well, thank you for coming, Franklin. I want to talk today about the role of a closing attorney
Yes.
in the process of someone purchasing a home.
Mm-hmm.
So when do you typically get notified, and by who, that a closing is going to be upcoming through your office?
So it's a fairly lengthy process, and if we're talking about on the buyer's side, oftentimes we're brought in when there's an offer that's been accepted. And I won't belabor these points too much because I understand you talked about them in the past, but you talked about buyer has an offer accepted, seller side drafts a purchase and sale agreement, and then we as the buyer's attorney make a lot of changes to the purchase and sale agreement to protect the buyer. We negotiate the purchase and sale agreement. We make sure that it's a sound, legally binding contract that protects the buyer, and specifically has provisions that ensure that buyer is going to get good, sufficient, marketable title, which, as you know, is the most important thing almost.
Right.
And at that point, once that's done, there are other stages in the process. You've already discussed. Perhaps the inspection's already happened. If not, the inspection happens. There are final water readings, fire inspections, septic tests, all those things that may occur between the time the P&S is signed in the closing. And then when the closing's actually about to happen after all of that, we have it on our radar because the purchase and sale agreement says the closing's going to occur on XYZ date. So we have that marked in. And then there could be last minute issues. Maybe there's a repair that still needs to be completed at the house, so the closing gets pushed back 4 days. Or maybe the seller says, hey, we're ready to close sooner. The lender says, yeah, we can close sooner. Buyer says, we'd love to close sooner. So now the closing gets pushed up 3 days. So it's always a moving target, but we always have it on our radar. The actual closing date is typically set in stone 3 days before the final closing date because of TRID. The buyer needs to be able to review the final.
So let's talk about if I am a seller
Yes.
or a buyer,
Yeah.
how many days prior to the closing do you get the information about the actual activity of the closing itself?
It depends on whether it's a cash purchase or a loan.
Okay.
If it's a cash purchase, you could have it 3 or 4 days. You could have all the final figures, and you could be prepared in that respect.
Okay.
If it's a loan, it depends on when we get the closing package from the lender.
Okay.
Sometimes it can be that morning
Right.
for the buyer. And if that's the case, then we have to kind of get into our job as a conveyancing attorney or a closing attorney. In one respect is to manage the funds. So we have a conveyancing account. We work with the banks. Obviously, we represent the lender in the closing, and we're moving the money. So if the buyer's not going to know exactly how much money they need to bring to the closing table until the night before or that morning, then we get into estimates.
Okay.
So buyer might need to bring $99,000. Buyer might need to bring $102,000. Let's get a check for $103,000. Buyer shows up with that, and if it ends up being $101,000, that day we'll just cut a check right back to the buyer to make them whole.
So let's talk about the documents that they should understand that they will sign at the closing itself.
Yes. So as they're working with their lender, one of the first things they're going to see is the loan estimate. And that's very similar to this document, the closing disclosure right here.
Can you get that? Yeah. Right.
Okay. And when you get to the closing table, this is one of the big documents that you're going to sign. And oftentimes it's the most important document for the buyer, personally, emotionally, and financially, because it details all the numbers. It talks about the purchase price, it talks about your loan amount, it talks about your interest rate, it talks about adjustments. If a seller has a oil tank or a propane tank and it's got some fuel left in it, there'll be what's called a final fuel reading, and a value is assigned to the fuel that's remaining. The buyer is going to give the seller a credit for the fuel. They're essentially buying the fuel. That number is going to be included here. If sellers have paid taxes beyond their quarterly taxes, if the quarter continues to run and the seller's already paid the taxes, then the buyer is going to give the seller a credit for those taxes, because now the buyer is going to benefit from those taxes. All those numbers are here. On the second page, you have your settlement fees, your recording fees, your title insurance fees, all the fees associated with buying a house. And we'll go through this document with the buyer. They've already gone through it with their lender in terms of an estimate. This is the final one. And we'll make sure they have any questions. Do you understand the fees associated with this? Do you believe there are any errors? If there is any confusion, we explain that to them so they understand everything that they're paying, how the numbers work. And we like to try to make sure that it fits together like a nice neat puzzle, and they understand what's going on. If you're a seller, you're going to have a seller's closing disclosure. You're going to see things like a payoff of your mortgage. You're going to see the real estate commission that you're paying. You're going to see city county tax stamps, which is a fee that's applied for
deeds excise stamps.
Yes, sale of real estate property. So you'll see all those fees on the seller's closing disclosure. That's the big one. But I think equally big for buyers, even though it may not be as emotionally charged, the mortgage and the note.
Okay.
I think for first-time buyers, the mortgage is kind of an exciting thing because you always hear about the mortgage, but I start with the note, then I go to the mortgage. The note is your promise to repay the bank the amount that's being lent to you. It talks about your loan amount. It talks about when your first mortgage payment is going to be due. It talks about what your principal and interest is going to be. Typically, it tells you that you're going to have a 15-day grace period. So if you pay your mortgage on the 6th of the month, the 7th of the month, the 12th of the month, that's fine. If you pay after the 15th of the month, you're going to have an interest charge. So you want to make sure you always pay your mortgage by the 15th. And it basically says you agree to promise to repay the bank the amount that's lent. And if you don't, now you're going to sign this mortgage, and the mortgage gives the lender the authority to foreclose on the property. And then we get into the mortgage. The mortgage obviously is a security instrument.
Right.
It's what the lender holds and says, hey, we've lent you this money, but we have a security interest in the house. If you stop paying us the money, we can foreclose on the property, take the house, and sell it to get back the money we lent you. Those are the big things. We try to make sure that people understand that. I think after those two, the next most important document is probably the homestead. Most people are familiar with the homestead. Some people don't understand the homestead, but basically what a homestead does is protect you from unsecured creditors. It gets recorded at the Registry of Deeds. It's a very simple document. You can only put it on a primary residence. You can't put it on an investment property. So you want to make sure it's on the house in which you live. But let's say that God forbid I leave here and I am driving and I get into a car accident and I hit someone and I injure them or kill them, and they file a lawsuit against me and they win, and the judgment is for $2 million, and I don't have $2 million to pay them. They might say, well, we're going to come after your house and take it to pay the settlement and the lawsuit. And I'm going to say, well, you're not going to be able to do that because I have this homestead, and the homestead protects me from the unsecured creditors.
So, and obviously, there's a deed involved.
Yes.
Let's talk about who prepares the deed and when it gets signed.
So the seller's attorney prepares the deed, and then it is sent to the buyer's attorney for review and approval. Oftentimes, the buyer's attorney will have the title attorney within the office look at it to make sure that everything is satisfactory. Typically, there will be some changes, and the seller's attorney and the buyer's attorney will agree upon a final draft of the deed. Once the final draft of the deed is agreed upon, prior to COVID, typically the seller would show up to the closing and sign the deed on the day of the closing. Since COVID, the customary conveyancing practice in our county and in the area has been for the seller to handle their portion of the sale remotely.
Okay.
So what that means is the seller will typically go to the seller's attorney's office 4, 5, 6, 7 days before the closing, sign the deed with a wedding signature, because we need the wedding signature, and give their attorney a limited power of attorney with a wedding signature, because you need a wedding signature on that. And then the seller's attorney is going to overnight that to the buyer's attorney, the closing attorney, us in our story today, and we're going to have it so we can record it on the day of the closing. And then what's going to happen is the closing attorney is going to email the seller's attorney the other closing documents that don't require the wedding signature. Seller's attorney is going to sign those under the limited power of attorney that the seller signed, and at least in our office, talk to the seller about what they're signing before they authorize the buyer's attorney to go and record the deed, which is oftentimes done electronically now.
Yeah. So how does your office typically record, and what do you record from that hypothetical closing?
So typically we e-record, which is more efficient, and it's ironic because our office is only 5 minutes from the Registry of Deeds. But in the past, a lot of closings would occur at the Registry of Deeds because they have closing rooms there, and closing attorneys could conduct the closing and then just run downstairs and record it. And that's nice and that's efficient. But you run into issues with, what if someone didn't bring their driver's license? When we notarize documents, we need to take a photo of their driver's license. So now you have problems. Maybe they have to call someone, and that friend has to take a picture of the driver's license at their house and then email it to someone. Well, if we're not at the Registry of Deeds, it's going to be hard for us to get the email. If we're at our office, we can print it out nice and easy. Let's say that the lender needs to do a last-minute document, which is very common. If we're doing the closing at the office, I can have my paralegal in her area typing up documents, talking to the lender, updating documents, making changes, walking them into me in the closing table. And then, if we have 4 closings in a day, it doesn't make sense to run back and forth to the Registry of Deeds, so we e-record them. And that's
80% of our recorded land documents are now recorded over the internet.
Doesn't surprise me at all.
Yeah.
Yeah.
Great.
Yeah.
And so in our rule, under our laws, when a deed is assigned a book and page number, it is deemed recorded.
Yes.
So what do you do after the deed is recorded? What actions do you take then?
So we keep track of the book and page number. We take copies of everything. Typically, a copy of the deed that's been recorded is sent to the buyers directly at their address. But we maintain copies of everything for up to 7 years. And then obviously the deed itself is a publicly recorded document. Yeah. So we advise parties.
As well as the mortgage.
Yes, and the mortgage as well, and the homestead. And if there's a trust involved, maybe a trustee certificate, any number of things could be recorded, but we always advise people that those are publicly recorded documents. So, if they're ever having any trouble, they can always go to the Registry of Deeds and grab a copy as well.
For $1 a page.
For $1 a page, yeah.
That's great.
Got to keep the lights on.
Well, anything unusual you see coming up in the future in the practice of a closing attorney?
No, not really. I think that, COVID kind of, installed a lot of new norms to the closing process that have changed the closing process. A lot more is remote. People are coming into the office less. Typically, you're only seeing the buyers at the closing table, not the sellers. And you're typically not seeing real estate agents at the closing as much, or lenders. But I think at the end of the day, that's probably more practical, because when you have the other parties at the closing table, that's nice. It's a social event and people enjoy it, but they can enjoy that after the closing over a cup of coffee or a lunch. So it's nice to be efficient at the closing table, smile, congratulate people, make sure they're happy, but also, at the end of the day, a real estate closing is serious business, and it's nice to not have the distractions and conduct the serious business.
Well, thank you for this discussion. Thanks for coming on the show. I totally agree with you. Post-COVID, our world has changed.
Absolutely.
In a lot of the things that we do and the way we do them.
Yes.
But thank you again.
Thank you.
Great.